Good morning, good afternoon, and good evening to all our attendees who are trickling in. Thank you all for being early. Now, we've had an overwhelming response to today's webinar, so we're just going to give it a couple more minutes for, everybody else to trickle in, and then we'll start in about 2 minutes. All right. Thank you, everyone, for your patience. Once again, good morning, good afternoon, and good evening to everyone, depending on where you're dialing in from. My name is Ian, and I'm very happy to be co-hosting today's webinar alongside my colleague, Natalia, who's our Resident Policy and Regulatory Affairs Director. Natalia brings with her a wealth of experience navigating regulatory challenges for crypto businesses around the world, and we're very lucky to have her with us today. Now, as all of you in this webinar are probably aware, 2025 looks to be very exciting for crypto. As you know, the Trump administration is pro crypto, and we're seeing a lot of crypto businesses start operating once more. Now, with that being said, regulations around the world are constantly developing. And so, here at Merkle Science, we do try to run a series of webinars where we regularly cover different regulatory updates around the world. With that said, we are very pleased to have everybody here today for our MiCA AML Compliance crash course. Now, just to kind of go through the agenda for today. So shortly, I will be passing the time over to my colleague, Natalia, who will be taking over for the bulk of today's session, where she'll be covering everything from pre-MiCA environment, its transition period, to the current requirements and other considerations that CASPs need to be aware of to operate compliantly. Now, if everything goes well, that will probably take about 1 to 1.5 hours. And then thereafter, we will take a short 10-minute break. So if any one of you need to use the washroom, get more coffee, please hold off until that time. Now, once the break is over, I will then be taking over to walk everybody through a short demonstration of a platform that we've developed here at Merkle Science called Compass, which is designed as a wallet and transaction monitoring tool to help crypto businesses stay compliant with their AML obligations around the world. During the demo, you will get firsthand exposure to what tools, crypto businesses use, how they can develop efficient rules and policies in order to conduct proper transaction monitoring. And thereafter, we will then circle back for a Q&A. Now, some of you might have noticed that the chat is disabled, and that is intentional because we want to make sure that if there's any questions from the audience that is captured, and then we will address them, for the benefit of everybody here. So for those of you who do have any questions, please do post them inside the Q&A. And during the break, Natalia will go through the questions and selectively pick some which she will address during the Q&A. Now, rest assured, just because we don't manage to respond to your question doesn't mean that you won't get an answer. In the interest of time, we might not be able to answer everyone. So for those of you who have your questions unanswered, do feel free to write into Merkle Science, and we're happy to follow up offline. Now, I also want to mention that, during the presentation, you definitely want to pay attention because at the end of the presentation, the demo, and the Q&A, we will have a short assessment, right? And upon completing the assessment and passing, of course, we will be issuing everyone a certificate as well, which you can share on your social media to demonstrate your competency in this area. And for those of you who are, interested in, let's say, how the MiCA is affecting, let's say, stablecoin issuers, I do want to also mention that Merkle Science has a MiCA Compliance stablecoin issuer certificate program that's currently going on. And more information can be found on our website. And, during this period, we are actually also running a 50% off promotion. So I will be posting the promo code inside the chat for those of you who are interested to upskill yourself more in this area. Now, with that said, we have a lot to cover today, so I will be passing time over to my colleague, Natalia. Without further ado, here you go.
Cool. Thank you so much, Ian, and thank you everyone for joining us today. So as you can see, we have quite a lot to discuss. So if you are all into MiCA regulation, you want to know more about MiCA, about compliance, you want to complain about MiCA, this is the right place to be. We will be discussing some of the issues as well that you may be aware of already. So maybe let's start with the context, because I don't know how many of you in the room are familiar with MiCA, so I will just give you a bit of context about what the regulatory framework looked like in Europe prior to MiCA, because it's quite important to understand how MiCA is actually changing the regulatory landscape here in the EU. So for those of you that don't know, before MiCA, the EU framework was primarily dominated by AML regulation. We had AML directive that obviously covered only specific parts of crypto ecosystem, right? Because we only had two main groups of providers that were captured within the regulatory scope. And those were crypto to fiat exchanges as well as custodial wallet providers. And that was limited to these two groups of providers. Obviously, some countries decide to go beyond, because let's remember that AMLD was just a directive, which means that countries could have implemented different measures. They could have opted in to include different types of providers, but also different types of crypto assets, because I would like to remind you here that only virtual currencies were within the scope of AML directive. Meanwhile, other countries could adopt stringent measures for other types of crypto assets as well. And because the primary framework was pretty much AML, we had the dominant authorization, which was AML registrations. So most of the countries in the EU, not all of them, but most of them, have adopted AML registration framework, which means that countries required or domestic VASPs or also foreign in certain occasions to obtain AML registration if they want to operate in the EU legally. And this is quite important to remember before we will go into transitional period, because there are several provisions for CASPs that were operating under national laws before MiCA, for example, with the AML registration in place. So we had a severe fragmentation in the EU at the time, and this is for several reasons. So I already mentioned that AML directive was obviously a directive, so we still needed national implementation, and countries could adopt different measures. They could expand the scope if they wanted to. And this is what essentially happened. So we only had virtual currencies within AMLD scope, but some countries decided to include different types of crypto assets within their framework. The same happened for the providers, because again, we only had these two groups of providers that were subject to AML obligations. And some countries actually expanded the scope to, for example, include crypto to crypto exchanges, because they were excluded. It was just crypto to fiat according to NALD. So there were several types of services that were included locally, but they were not included at the EU level because countries decided to go beyond. Another thing is AML requirements. So what I'm trying to say here is that AML requirements are not unified globally, right? We do have FATF standards, obviously. AML directive is in place, and most of the requirements, they are pretty much similar, that's true. But we still have nuances, right? So between different countries, you can have different methods for identification, verification, more stringent measures in some countries, beneficial owners checks, etc., access to registries. So these requirements will differ slightly. So basically, VASPs are subject to different regulatory oversight. There are different requirements in place. So we had kind of fragmentation even when it comes to AML compliance, which is still fairly unified. Another reason for fragmentation was regulatory framework. So as I mentioned before, most of this was pretty much AML registration. However, some countries in Europe decided to go beyond this AML registration. And they decided to opt for different regulatory framework, which would be like bespoke regulatory framework. For example, Malta implemented their act, which was designed for crypto asset services in mind. It wasn't just the extension of AML regulation that we had. It was a new framework similar to what we have with MiCA right now. So they went beyond. They didn't just rely on AML, that AML has to apply to crypto. They went beyond to include conduct prudential standard before MiCA was even in place. And this is also why we have different authorization. We had different authorization requirements in Europe at the time, because most of the countries still required AML registration, but in some countries we had license, which was a bit stronger than just pure AML registration, or we had a full authorization, like for example in Malta. We also had that in Germany for certain activities. So as you can see, there were just different requirements applicable in every member state, which caused significant fragmentation. But it was also challenging for CAS because they had to navigate completely different requirements across different countries. And that was particularly painful in terms of authorizations, because some countries only required domestic CASPs to register or obtain authorization. But other countries also wanted foreign CASPs that operate cross-border in their jurisdiction to obtain that authorization. So even though you were headquartered, let's say in Belgium, you might have to acquire a new license in France or Italy, depending on the local regulator and the expectations whether foreign CASPs have to register or obtain authorization. So I think that I'm just trying to make a point here that we had that fragmentation before, and this is what MiCA obviously wanted to change. So just wanted to clarify one more thing before we go into MiCA specifically. So we had AML dominated framework, right? With certain obviously nuances in different countries where we had more than just AML framework. So we had AML requirements in place, we had AML registration in place, which means that companies were also subject to AML supervision. But what we didn't have was conduct rules, prudential requirements, no actual consumer protection, no disclosure requirements. So this is how regulatory landscape in Europe was before. It was fragmented, it was AML dominated, and we didn't have a proper authorization framework for crypto asset service providers. And this is quite important to note because even, let's say, before Brexit, the UK has also adopted AMLD into their national framework money laundering regulations, right? So it means completely different thing to be registered by the FCA and authorized by the FCA, right? Because AML registered means that these companies are pretty much subject to AML requirements only. They are AML registered, they are MLR supervised, but it doesn't mean that they have prudential requirements. It doesn't mean that the company is liable in case something goes wrong. It doesn't mean there is compensation scheme. So I just wanted to make that distinction because this is something that MiCA will be changing later on. So going back to this point, MiCA goals, obviously we can talk about the execution, which was poor in some areas, let's be honest. But the main goals of MiCA was to obviously extend these requirements, right? To include prudential and conduct rules that were not in place in most of the countries before. It was also to harmonize these regulations to make sure that CASPs can also operate more freely and easily across the entire EU, which would be obviously based on the authorization, where we would have like standard requirements for all CASPs. This is obviously debatable if that's what's actually happening, but that was the main idea, to have this one authorization standard where that you can passport in other countries where you have this authorization in your in your home state. So one thing here, before we actually go into MiCA, because we talk about how MiCA impact the European Union, But it's also good to remember that if the regulation is considered relevant, it will also apply in a wider European economic area, which is what happened. We got the decision on 20 February 2025, and MiCA was incorporated into the agreement and is already in force. So countries like Norway, Iceland, or Liechtenstein will also have their MiCA national implementation in place. So about the timeline, because we will obviously discuss transitional period as well, because right now we are in transitional period. So it's quite important to know that we had different time frames when it comes to MiCA compliance when the rules were actually applicable. So most of the rules for stablecoin issuers, they were already in effect in June 2024. So we are basically nearing a year right now. But the requirements that we'll be discussing today, so the rules for CASP specifically, they are applicable as of December 2024. But this is with one nuance, transitional period, with the maximum period till July 2026, which means that we can still have some sort of fragmentation till July 2026, depending on what happens at the national level, because the approaches are different. So now we'll dive into transitional period because this is what's happening right now and it's interesting for the companies. So as I mentioned before, for crypto asset service provider, we can have transitional period of up to 1st July 2026. Technically, the countries had to decide whether they want to opt out of this transitional period or they want to reduce the duration. We know that this didn't really happen on time because some countries were still figuring out what to do a few months ago, and probably even right now, there are a few countries that don't even have confirmed regulatory authority that will be supervising CASPs. But the most important part is July 2026, because this is the ultimate deadline. This is the maximum time of 18 months where crypto asset service providers will be able to operate under existing frameworks, and they have this time to obtain MiCA specific authorization. But that transitional period, this grandfathering clause, does not apply to all CASPs, and we'll be discussing it later on. So the first problem, I would say, is that is causing still fragmentation for up to 18 months, is that this is not mandatory. Transitional period is not mandatory. So it's basically up to the member state to decide whether they want to provide their local CASPs with this additional period of up to 18 months. But they can also take different decisions, right? They can or adopt the full period, which is one of the most prevailing choices, but they can also reduce the period, or they can opt out entirely, which hasn't really happened. I know there were plans long time ago. I think in Germany, they wanted to opt out entirely, but this is not what happened. But yeah, these are the main three options that the countries had. And it's quite helpful. I will share the presentation obviously after the webinar, but I attached the link where you can actually verify list of grandfathering periods decided by member states. It was published by ESMA, so you can verify what is the actual transitional period. And in some cases, it's actually quite short. Some countries decided for 5-6 months. So we are basically nearing that period right now. So it will be quite interesting to see if it will be actually possible to achieve what they wanted to achieve in 5-6 months of time. But we'll see about that. So before we discuss, obviously, what to exactly consider is just initial considerations before we dive into the actual, like, which CASPs are in scope, which are not. So what is this transitional period? So for CASPs, so crypto asset service providers, it's pretty much a time to adjust your compliance strategies, to restructure your business, and to obtain MiCA specific authorization, or to leverage traditional financial regulation if you already have authorization in place, right? So this is basically the briefing room for CASPs to make sure that they actually have a bit of time to restructure their business and adjust everything to make sure they can be MiCA compliant. But we often forget that regulation is, you need to tango, right? There are also regulators. Regulators also need time to adjust because they need to adjust their supervisory practices. They have new authorization framework in place. They need resources, internal resources like teams, expertise, probably data tools as well. So it's also giving them time to understand the process that they want to put in place and to see how it works in practice. So it pretty much works both ways. But for that reason that I mentioned before, we may have fragmentation till July because in some countries, transitional period will be shorter than in the others. And we often talk about, which countries should be the best country to obtain MiCA specific authorization. I obviously can't tell you what that country would be, but I can tell you that it's worth looking at the number of existing CASP in specific country when you are looking to establish your operations and obtain authorization there. Because if you have a local regulator that will have more than 1,000 CASPs registered, and let's say all of them applied, we don't know, probably most of them will not. But let's say you have all of them or half of them that applied. It's 500 CASPs applying for authorization. And if the period of time is fairly short, like 5-6 months, you may not obtain authorization on time. We don't know if these regulators will be able to process this amount of applications on time. And, a lot of people, I think, believe that, oh, it's great. I have 18 months more. Yes, if that's the case in your country, you may have 18 more months, but there is one caveat here. You don't have passporting rights, right? Because they only apply to MiCA authorized CASPs already. You can't operate in every single member state of the EU, leveraging your existing registration, let's say, in Belgium. That's not possible. You can only operate in countries where you already have existing registration, like AML registration, but it doesn't mean that you can passport this registration across the union. This is not how it works. That's why a lot of CASPs are actually thinking about it strategically to secure authorization earlier, because the earlier they get authorization, they can provide services across the entire union and they don't have to work out what happens to the existing customer base if they are based in different jurisdictions. Just to add a bit of fun touch, because it basically applies to CASPs that, already have some existing authorization in place. It doesn't apply to new CASPs that will be established after December 2024, right? But let's remember that they still have to apply for the actual MiCA authorization or to leverage traditional finance authorization like being EMI or MiFID authorized firm. You can't transform your existing AML registration into MiCA authorization. This process is not automatic because MiCA authorization is more than just AML registration, and you will have to prove that you can comply with a set of completely different regulatory requirements. So what I was trying to say before as well with the choice of jurisdiction, as you can see, that's just one of the jurisdictional examples. We have Poland, right? It's 6 months. This is a transitional period. It's 6 months. But you can see on the left side that you have, as of 27 December, you had 1,841 VASPs. So basically what you have to think about is whether the Polish authority will be able to process 1,841 applications in 6 months if all of the CASPs actually apply for authorization. So that's what I wanted to point out when you are choosing jurisdiction, because you need to make sure that the regulator also has resources and you have enough time to obtain authorization in specific jurisdiction. You need to consider the local resources as well, because some regulators will be more advanced than the others, some will have more expanded teams than the others. So it's quite important to understand what's the underlying infrastructure like in a country of your choice. So now we'll discuss every single one of these points in the next slide, but I just wanted to tell you about different things that you have to consider during this transitional period. So we will start from AML, or actually let's start from scope, that will be probably better. So this transitional period of up to 18 months, obviously depending on your local context, it only affects the CASPs that were already established before that date. So if they were obviously operating in compliance with the laws. So if you had a Polish CASP or French CASP that was registered for AML purposes, for example, they may still have this extra time to adjust their policies, procedures, obtain authorization, because they were already compliant before. But it doesn't apply to new CASPs that will be established after that date. MiCA will be applying directly to this CASPs that establish after that date. This is just a briefing room for the actual existing CASPs. And a few things to consider here. Passporting, I already mentioned that before. You can't leverage your existing registration or authorization for passporting purposes. You can only, provide services in a country where you are legally registered and have like AML registration license or authorization. You can't passport it in another country during that period, which is obviously causing a lot of friction. You may also want to consider regulatory shifts, because we had VASP supervisors before that were registering CASPs, licensing, issuing other types of authorizations. Not all of the supervisors will be the same after MiCA, because some of the powers are shifting. So, for example, in Ireland, we had Central Bank before MiCA, and it will still be Central Bank of Ireland with MiCA. But in certain countries like Netherlands or Italy, these regulatory powers will be shifting. There will be different CASP supervisors. It's not necessarily the same supervisor you had before MiCA. And now 3 considerations about compliance with other regulations during this transitional period. So we do have AML. AML compliance is still mandatory, right? We don't have any exception provided here. And the reason is quite simple. We had AML directive before. These CASPs had to comply with AML before MiCA. So why there would be an exception to comply with AML? Because these regulations were in place already. So remember that no exception for AML. AML continues to apply as it applied before. Now travel rule, because we also know that we have TFR, and TFR applies also from December 2024. There is a small transitional period for travel rule, but this is only for some technical challenges and barriers that CASPs may have if they can demonstrate that it's an actual obstacle. But it still doesn't mean that they, can say, oh, okay, there is a problem. I don't need to comply with travel rule till July. No, that's not true, because you still need to comply with travel rule. You need to have alternative mechanisms in place and solutions to transmit the data securely, to receive the data, to verify the recipient and the originator of the transfer. So travel rule is already in place with only a few months transitional period, which is only for technical challenges, not for the actual travel rule compliance. And then we have market abuse. We have market abuse under MiCA, and these provisions are already in place as well. There is no transitional period for that part of compliance. And as of now, for those that are obviously interested, if you want to compare the status of your counterparty, you can obviously access the interim register, because some CASPs already secured the proper MiCA authorization or leverage their existing authorization. So we do have this interim register where you can verify which CASP is authorized by which authority in which country. In which country it's also offering services based on the passporting rights, etc. So this interim register is obviously your source of truth as of now, but interestingly, now you can also find non-compliant CASPs on the list that were, I think, added by Italian regulator recently. So in this register, you have all the CASPs. You also have white papers, but this is a different story. You have stablecoin issuers, but also non-compliant CASPs. So just a quick reminder here, July 2026 is the ultimate date if your country opted for 18 months. After that date, the compliance is expected from every single CASP that was existing before MiCA was in effect for CASPs. So make sure that you obtain authorization and have everything in place by that date if your country allows you for full 18 months period. Now let's talk about the scope. So we obviously talk about CASP compliance just as a reminder. So we'll be discussing crypto asset service providers, not stablecoin issuers today, just to make that note. So we have three groups of persons where regulation applies. So we have natural persons, so individuals like me. Then you have legal persons, so incorporated companies, entities that have their legal wrapper, right? And then we also have other undertakings. So basically entities that are not incorporated in entities. That could be partnership, trust, but it's also quite important for DAOs, which I will discuss later on. Because technically, if you are a DAO, you are considered as other undertaking. It doesn't mean that you are escaping MiCA compliance just because you don't have this legal wrapper. So on that note, on other undertakings, we don't have the actual definition of what other undertakings is, but we do have European Court of Justice ruling that is interpreting the term as an entity engaged in economic activity regardless of its form of structure. So as you can see, the scope is broad to make sure that we capture every type of person, organization, entity that is providing crypto services. But there is a but for other undertakings. It's not as simple as it seems because there are some limitations. As you can see under point 1, other undertakings may provide crypto asset services under certain conditions. So, for example, their legal form must ensure a level of protection for third-party interests. They must be subject to prudential supervision that is appropriate for their legal firm as well. And that's a good question about long-term sustainability of certain projects, because in many cases, complying with regulatory requirements may actually prompt you to become incorporated entity because it's simply easier to get some protections in place, to get guarantee in place, to get insurance in place, etc., which basically will be the requirements under MiCA because it's all about the consumer protections. So just wanted to give you that extra insight here that a lot of projects that I know are thinking about restructuring because they don't want to have this personal liability either. So ultimately, it will be a question of providing business in a secure way, not only for consumers, but also to protect business interests as such. And second point, I already mentioned before, and under this term, other undertakings, we can also find DAOs, which we will be probably discussing a bit more as we go further. So about scope, we know that MiCA applies to crypto asset service providers. And that's why I wanted to start with the introduction of what we had in the EU prior to MiCA, because I wanted to point out what type of services are currently subject to regulation and what we had before. So under AMLD, as a reminder, we only had exchange of crypto assets for fiat, and we only had custodian wallet providers. As you can see, this list is much larger. there are different business models and services in place that are subject to regulation. I'm not going to read it out to you. I'm sure you are familiar with them, but it's just to let you know that the scope now is much broader. There's the bigger scope of services and sometimes activities, not just services, that are subject to regulatory requirements. So as a reminder, if you are a natural person, legal person, or other undertaking, and you are providing one of those services, you may have to obtain authorization in the EU, which we will discuss later on how to do that specifically. Let me just have a sip of tea before we go into DeFi, which is one of the favorite topics for many people here. So around DeFi, MiCA technically has provisions around DeFi. We know that it doesn't apply to fully decentralized services. MiCA makes a distinction between fully decentralized and partially decentralized. The only problem is that we currently have is that we don't know what fully decentralized means for EU legislator. And that's the big problem, because technically we do have that exemption. We do have fully decentralized services exempt from MiCA. However, we don't really know what that exactly means. And I don't think we will find out anytime soon. Unfortunately, I think we will see enforcement actions, or we'll see rulings coming from European Court of Justice to clarify some of these boundaries. But this is problematic, right? Because even when we think about decentralization, first of all, we don't have that regulatory definition. We don't have that regulatory threshold that defines when it's fully decentralized, when it's partially decentralized. And it's quite difficult to entertain the idea of sufficiently decentralized. The US tried to do it. It didn't work out. It's just very difficult to think about this regulatory threshold. And also, when you think about decentralization, there are different angles, there are different forms of decentralization. And even if one system can be partially centralized in some of these aspects, it can be decentralized in the others, right? And when you even read the reports from like IOSCO or CFTC in the US on DeFi, they also say that decentralization exists on a spectrum. It's not an absolute concept, which is absolutely right. We do have some indicators in place that we could obviously use to think if the system can be viewed as fully decentralized. We can look at the distribution of the power, smart contracts upgrades, if there is some element of custody, developer influence, founders influence, allocation of governance tokens. So there are a couple of indicators you could look at. But in my view, a lot of projects that we reviewed, working with the product team, obviously, they are far from being fully decentralized, which means that they would still be subject to MiCA. And that's quite problematic because we don't have that definition. We don't have that regulatory threshold. But on that note, because we work with few projects, and what I see myself, that a lot of people confuse decentralization with disintermediation and automation. So let's just make it clear that decentralization is about the governance, it's about the actual governance power, etc. Disintermediation can be an outcome of decentralization because you may not need intermediary in the process. And automation is obviously removing the processes that would be otherwise manual, which again can be the outcome of decentralization. But these three concepts, there are three different definitions, right? Because system can still be centralized. You can still have governing party, but they may remove intermediaries between transactions, or they can automate certain transactions. They can automate processes, but it doesn't mean there is no central entity. And the other way around, it can work the same. But for more interesting things, just one note here on the governance tokens. We got clarity from ESMA in their guidelines, and because a lot of people were actually concerned that governance tokens could be viewed as security tokens. So basically, they will be subject to MiFID, which is also stringent traditional financial regulation. But we did get the clarity that these ministerial administrative activities, these tokens, are not considered security tokens. So that's a welcome change for the industry, that if this is just, I don't know, voting around governance, upgrades, security, etc., this will not be viewed as an actual security token, which is more about the corporate decisions, dividends, etc. So that's completely different, and we get that clarity. But on that note, that was the positive note. Now let's go to more negative notes to consider, because we have fully decentralized exemption under MiCA. That's great, but we also have to consider that MiCA can work with MiFID. So you can think of a situation where you are providing crypto asset service in fully decentralized way, but in relation to token that is viewed as financial instrument. If it's viewed as a financial instrument, so it's derivative, share, equity, bond, etc., there is no decentralization exemption under MiFID. They didn't think about it, right? So if you are providing service in fully decentralized way, but it's in relation to equity or bond or derivative or collective investment scheme, unfortunately, MiFID doesn't have that exemption. So sometimes the projects may think that they actually, run away from MiCA compliance, but they need to consider if they are not subject to MiFID instead, which is obviously subject to in-depth legal analysis that we will have to do with the help of your product team, because you need to understand everything at a technical level as well. And now from DeFi to staking, because a lot of people I talk with, they believe that staking is outside of MiCA. They said that UK is looking into staking, which is a difference, which is a big difference from the EU approach. That's not entirely true. We did have the Q&A answered by European authorities, and we actually learned that we have to distinguish between two forms of staking. One would be custodial staking, which is pretty much where you actually you have custody over customers' funds or crypto assets. In these cases, if we have this ancillary service of custody, there are elements of custody, they would still be subject to regulation because there's custody in the middle. If the staking is non-custodial, then most likely it will fall outside MiCA's scope. But a lot of platforms, like staking as a service platforms, do have that custody. So it's quite important to consider these elements of custody, because they may determine whether you need to obtain regulatory authorization under MiCA. So now about authorization. We went through the scope. So now let's see what you have to do if you actually need that authorization. So first, let's start from the territorial rule. So that's quite a controversial topic in general about the territorial rule. As many of you will probably know, we are basically creating Fortress Europe, but that's a different topic. So if you want to provide crypto asset services in the EU, it's quite straightforward. You need authorization, right? Quite simple. But there are technically two ways. One is obviously authorization. So you need to obtain specific permission from regulatory authority in your home state. Or if you are a foreign CASPs, you may need to establish the operations in the EU in the first place to obtain that authorization. There is also a concept, very controversial concept recently, of reverse solicitation, which basically means that if you are a foreign CASPs and you do not target the EU customer, you do not advertise in the EU clientele is not your target base, and you are not doing anything to actually request that service from them, you can rely on the reverse solicitation exemption. Whether you can or not, we'll discuss later on, but technically, we do have reverse solicitation exemption, which should be viewed actually as a prohibition that you can't provide services without authorization, unless this is at customers' own discretion where they decide to use your services because, for example, they think that they can't get the service in Europe at the same level as they can get it in the US. That's the customer's choice, right? We should be able to allow them to choose the provider they want to use. So now I'll go a bit deeper into that. So for authorization, also I see questions coming. I will be reviewing them after the presentation. We'll address them later on. So around authorization, if you are EU-based CASP, you need to secure your authorization. Like that's non-debatable. That's like white and black. You also can't leverage reverse solicitation if you are EU CASP. That only works for non-EU foreign providers. It doesn't work if you are based in the EU, just to make that note. But it's not just EU CASPs that need to obtain authorization. It's also the foreign CASP if they are planning to obviously participate in the European market, if they want to actively market and offer their services, if EU clientele is basically their target group. Obviously, it's a bit more complicated for them to do it because they need to set up the operations in the EU in the first place to actually obtain the authorization. So basically, they need local presence, they need local execution venues, local directors, and effective management in the EU. So if you are a foreign CASP, you can't just operate from across the borders. That's unfortunately not possible. And you will have to establish a proper setup in the EU. And by setup, I don't mean just like a mere legal registration. You need an actual effective management place here. You need execution venues here. ESMA was quite clear about it with their opinion on broker models as well, because a lot of CASPs think they will be establishing the mere presence here for the sake of getting authorization, but all the execution will be happening through the outside the EU channels, which shouldn't be possible, shouldn't be allowed. So as you can imagine, this is complicated. This is lengthy process. You need to have a lot of budget to actually set up these operations, make sure that you actually have a proper EU presence, not just a mere legal cover that, hey, I'm there, but you are actually not there. And this is quite important because obviously we can think about it what we want, right? I know it's complicated, it's costly, it definitely is. I'm not saying it's not. But it's more from regulatory perspective. They want to make sure that they can actually enforce regulations. And it's always difficult to enforce regulations, target enforcement actions, if the CASP is actually located outside the EU. So that's probably one of the reasons why we have that strict requirements. And just a reminder here, because I don't remember if I have it in the next slides, we don't have regulatory equivalence arrangements. Regulatory equivalence arrangements are basically, how to say that, if you are in different country and you are regulated by certain institution, let's say SEC in the US, in many cases, we have like the agreements between the countries where we agree that, hey, because you are authorized by this regulator for this specific activity, we can actually consider that your regulation is equivalent, is strong enough, it's similar to the European regulation. So in some cases, we can leverage that. It's quite popular in traditional finance, but also in not in the fields that are not related to finance only, because it can be about the medicines, about many other stuff where we could consider attestations equal. So we don't have that for MiCA. We don't have it as of now. I think that the EU authorities, just correct me if I'm wrong, because I may have forgotten the date. I think it's still 2027 when they actually have to think whether this regulatory equivalence arrangements should be in place at all. It's not to put them in place. It's to make sure that we made an assessment whether it's something we want to potentially leverage in the future, which obviously would be beneficial because the way to access the EU market would be much easier, much quicker, and less costly. And also European customers would have more choice when it comes to the crypto services. And this is just what I mentioned before. It's quite useful if you are a global VASP, so you can actually see what's the ESMA actual view on global crypto firms using their non-EU execution venues. There are quite a lot of indicators that you can go through to see whether ESMA considers you as being actually established in the EU and executing the service in the EU, because in some cases, again, it's a mere legal cover and everything is happening outside the actual EU infrastructure. And now reverse solicitation. It's quite complicated. I'll just put it this way, especially with the recent statement that we got from European authorities. So technically, we do have reverse solicitation under MiCA. Technically, if you're a foreign provider, if the client reaches out to you, they want to initiate the process, they want to get your service, they are allowed, because the customer should be allowed to choose the vendor of their choice. But the recent guidelines that we received are going a bit against the letter of law. Obviously, you may have different opinions about it, but I just wanted to note that this reverse solicitation became very, very, very narrow, and it's very challenging to actually demonstrate that this is reverse solicitation and that you did everything you could not to solicit the customer. And just before we go more into that, just one reminder, I think I already talked about it before, but let's remember reverse solicitation is for foreign CASPs. It's not for EU CASP. If you are a French CASP, you can't rely on, well, someone in Belgium wanted to get my service. And no, you need authorization because you are based in the EU. So that's non-negotiable for the CASPs that are based in the EU. They can't rely on reverse solicitation. And now let's talk about the solicitation term, because we got this recent statement, which obviously caused a lot of debate. The biggest problem was that technically we have reverse solicitation exemption, but under the guidelines, it looks like just being barely visible in the EU means that you are soliciting customers. And there are quite a few examples where we were on the line between the actual solicitation and just working on a brand awareness or marketing campaigns, because there were a lot of considerations for marketing, the SEO optimization for your web engine, etc. It's about your digital footprint that you are leaving in like the search. So if you, for example, I don't know, if I'm the crypto asset firm and I discuss MiCA as a, I don't know, blog post, let's say it's a blog post about MiCA compliance. Well, it's not solicitation, right? Just because someone is putting in a search like MiCA guide, it shouldn't be viewed as solicitation just because my company is in a search and I'm not the EU company, if I'm just discussing the regulatory trends. Now that line, it's very blurred, because just having this digital footprint, discussing relevant topics for the EU, like compliance, etc., may be controversial. But the most controversial part is that ESMA is basically telling us, hey, you can rely on reverse solicitation, but on the other hand, we want you to geo-block the customers in the EU. So how do you work with reverse solicitation here? Because the whole point was to make sure that the service is accessible for the customers that want to use it. But we basically make it impossible to rely on that reverse solicitation, because we tell companies to geo-block the means of access. And this is one of the best way to prove to regulators that you are not soliciting the EU customers. So again, there are different opinions about it, but obviously it makes that reverse solicitation a bit unworkable, if not possible at all. And in my view, it's just turning it a bit into theoretical concept. And I also personally don't think that was the intent of MiCA. This is just a meme from Nathan Catania, probably you know him as well. He literally said after these guidelines, one does not simply service the European market for reverse solicitation. And that's kind of true, because no lawyer will safely say, yes, you can rely on it in the view of these guidelines that we received recently, because we don't know what will be the actual outcome of providing the services relying on reverse solicitation, because there's so much that you can do to actually trigger the regulatory scrutiny, because it's the SEO optimization, it's sponsoring a European football club or the, I don't know, Euro. It's basically being visible. So just being visible means that you may be viewed as soliciting customers, which is obviously a very tricky situation here. And this brings me to my last point. This is not about MiCA specifically, but a lot of people are raising the problem that we currently have, which is the normative inflation. Because technically, we have the regulation, which is our level 1. We have the letter of law. However, we have a lot of level 2 and level 3 acts. So like RTS, Q&A, a lot of soft law, like guidelines, recommendations, etc. Technically, they are not binding law. Like soft law is not a binding law like MiCA as a regulation, right? But what we've observed is that with certain situations, we can see that the authorities like ESMA or EBA are moving away from the literal interpretation of MiCA and are adding and reshaping the regulation, like the interpretation through the soft law, which shouldn't be happening. There is a good report on that. I think it's called EU, The Less is More. So if you are interested, I recommend the read. But it's basically discussing the topic that we have the actual text of the regulation, but all these interpretations, all these guidelines seem to be diverging from what we thought was the intent of the actual regulation, which is example of reverse solicitation, which we don't think it was supposed to be viewed as complete prohibition and just discourage every CASPs to even have a digital footprint in the EU. That I don't think that was the intent, but this is what's happening. And the problem with these recommendations and guidelines and QAN is that regulators usually follow them, and they also expect the institutions to actually follow them as well, even if it's diverging from the actual letter of law. We may see companies challenging that in future. I would love to see that, if I'm being honest, but I think as of now, everyone will try to stick to what the actual guidelines are, because nobody wants to be the first one subject to regulatory action. And now coming back to the actual authorization after discussing territorial scope. So there are 2 ways to actually become authorized under MiCA and provide services in a compliant way. So 2 ways. MiCA authorization, so pretty much applying for MiCA specific authorization. The whole process is laid out in regulation. Or if you have it, you can still rely on existing financial regulatory approval. These are 2 different ways that we'll be discussing. And if you look at the registries that we already have, it's the interim register that I also mentioned before. You can actually see what is the type of authorization, whether it's CASP authorization under MiCA, Article 63, or is the CASP notification under Article 60 MiCA. So basically, Article 63, you have to obtain authorization. Article 60, it's leveraging your existing authorization that you have in traditional finance, but you still need to notify your national competent authority. It's not purely automatic. You still need to notify. And in many cases, you still need to provide extra documentation about the crypto asset service that you provide, because you may have gone through all the checks for traditional finance, but let's remember that there are also specific obligations for specific crypto asset service. So in many cases, these CASPs, yes, they can leverage their existing authorization, but they still may have to provide some information about what they change in the policies, procedure, structure to comply with MiCA specific obligation for crypto asset services. So now a bit more about leveraging that traditional financial regulation. So if you are a credit institution, central securities depository, market operator, EMI, or MiFID regulated firm, in many cases, you obviously don't need that MiCA authorization because you are already subject to regulation. You went through the very rigorous process, which can be different as well, because let's remember that MiFID, for example, is the directive. So the regulatory requirements and the regulatory supervision may be still different in these countries. And again, you are just leveraging your existing financial regulation. But let's just make it simple. If you have these authorizations in place, in most of the cases, you can simplify your process and you can notify that you want to engage in crypto asset specific activities. And for certain firms, like MiFID firms, it's quite important to understand equivalency concept here, because you can leverage your existing authorization for the services that are considered equivalent to what you are authorized for already. So this is just a simple example on the right. You can see portfolio management, right? If you are authorized for portfolio management, you can provide portfolio management on crypto assets under MiCA, because this service is deemed equivalent between MiFID and MiCA. So that's quite an important note that we need to think of equivalency. When I talk to some lawyers working with MiFID authorized firms that actually want to provide a crypto asset service, which is not equivalent to their actual traditional finance authorization, they were asking whether you need to actually obtain MiCA authorization in addition to it, if it's not equivalent. The answer was no. Most likely you have to just alternate your existing authorization under MiFID, but obviously it will probably depend on the national competent authority and their approaches there. And we'll probably find out more during this transitional period about, supervisory practices in this specific aspect. And just from practical perspective, just wanted to note that you can also see if the VASP CASP in the register is the CASP that notified that they want to operate under the same authorization they already have. You can also see which activities they are leveraging for that specific service. So as you can see on the left, we have authorization for the one company for exchange of crypto assets for funds, other crypto assets, and execution of orders, which are equivalent to the services we have on the right. And this is coming from the regulation directly, which is there attached in the very bottom. And the most important thing, passporting rights. So basically, if you already have authorization in the EU, if you have MiCA specific authorization, or you successfully notified that you want to leverage existing regulation that you have, you may be leveraging that specific authorization to provide services across the entire EU. Sounds great, right? But in practice, I think that there will be some practical issues. I don't think that all national regulators will be accepting it straight away. I think there will be some extra process for some countries where they will still evaluate the process that the CASP went through in the other countries. Obviously, I don't really work with authorization, so I can't speak to it, but I've heard a lot of voices that it may not be as automatic as we think it will be. But just again, from practical perspective, you can see the EU passport, how it's leveraged, in which countries the companies can operate, because they also have to notify. This process again should be more automatic. It's not automatic because you need to first say to your local regulator, hey, I want to operate in those countries. Then they, on your behalf, they talk to other regulators in these jurisdictions and make sure that you actually are able to do it. So it's not exactly automatic, and there can be more involved, and we'll see how it goes during this transitional period. And now about requirements. Obviously, we'll not discuss every single one because we would probably need a proper session for every single one of them. But I just wanted to note that we have two sets of requirements for CASPs. So we have one general set, which will be applicable to every single crypto asset service provider. So regardless of the service that you actually offer, it's applicable to all of you. So you all have to comply. And then we have the specific set of requirements, and this depends on the service that you actually provide. So two sets, general for all of them and specific ones depending on the service that you provide. That's why in the previous slides, I tried to show you the list of crypto asset services subject to MiCA, because most of these services will have additional set of requirements that you will have to consider because they are specific to this service. And just on the practical side here, because we have these two different sets, this is also how authorization documentation works. So you have two different sets of documentation. One would be the general application pack, and then specific policies, procedures, etc. for specific activity type that you provide. So just to make that note. So again, we have general requirements, and you can see them on the left, like obligation to act honestly, fairly, etc. We have prudential requirements in place, which is obviously a big change from what we had before MiCA, because in many cases we didn't have any prudential requirements. We have governance arrangements, rules around safekeeping of clients' assets and funds, compliance handling procedures, which are now mandatory and also free of charge. We need to identify, prevent, and manage conflicts of interest, whether detrimental to clients or detrimental to the company itself. There are rules around outsourcing. So as you can see, we have all the prudential and conduct rules and consumer protection rules that we didn't have in place before MiCA. So we didn't have them when we had AML dominated framework in the EU. And obviously prudential requirements are one of the biggest changes that we have, because it means that you need to keep some minimal capital to cover in case of unexpected scenarios as well. And there's a lot, obviously, about type of capital that you must hold, which usually has to be very liquid, risk-free. And this is because of the liquidity, right? Because having capital is one thing, but whether it's liquid or not, it's another. So you can think about having a house. You technically have a house, right? It's your capital, but how easy it is to liquidate your capital. It's not a straightforward process. You can't convert your home into cash immediately. So that's why there are several prudential requirements about the type of reserve that you must hold, the amount of reserve that you must hold, and also obviously the types of the assets that are permitted to make sure that you can meet the, for example, redemption requests, withdrawal in case of some stress scenario. And then we have specific activities. So for these activities on the right, we have set of specific requirements that we have depending on the activity. So for example, for a custody and administration of crypto assets, we'll have custody policies, contractual arrangements between client and the custodian institution, etc., segregation of funds. For operation of a trading platform, you can have listing procedures, privacy coins, etc., all the stuff that is relevant for the specific activities. I will discuss a few more things that are not the specific activities, but I think it's quite important to note. So CASPs, when providing crypto asset services, they can't grant interest to holders, right? So basically, if you have stable coins, whether it's e-money tokens or asset reference tokens, these CASPs cannot provide the yield. This is one of the most controversial provision under MiCA, debatable by many, but this is what it is. We have to work with what we have. So as of now, we can't grant interest, but it's not just CASPs, it's also stablecoin issuers themselves. And also a good meme by Jonathan. You probably know Jonathan as well. He was discussing the topic very in depth as well. And now a bit more about so-called non-compliant stablecoins. That's a controversial topic. I think I have a few slides about this. So let's say that we have stablecoins issuers in the EU or outside the EU, and they do not have MiCA authorization. They are not EMI, they are not credit institution, etc. They are not approved stablecoin issuer. Technically, based on the guidelines that we received quite recently, trading platforms, just kind of reminder, operating trading platform is specific crypto activity. It just applies to trading platforms. These trading platforms cannot provide services in relation to stablecoins that were issued, but issuers that were not authorized under MiCA. And this is quite controversial for many reasons. And this is where we also can observe the normative inflation phenomenon here. And why is that? So let me try to explain it in a simple way. The whole problem is actually about the issuer authorization. Let's say that you want to issue a stablecoin in outside the EU. Let's say you are the US issuer, in which cases you need to obtain authorization in the EU. When obviously you want to offer that stablecoin in the EU or seek its admission to trading. In these cases, you need to be authorized under MiCA as a stablecoin issuer, even if you are a foreign issuer. You need to meet all the requirements to offer it in the EU. But let's think that then we can think about two different situations, right? So if we have the issuer that wants to engage in these activities, it offers the stablecoin to the EU or it seeks its admission to trading as their own initiative, they would require authorization because they are actually involved in regulated activities. The issuance itself is not regulated activity, with one exception of issuing EMT pegged to euro currency. But in general, issuance itself is not regulated. It's the offer and seeking admission to trading. In these cases, if the issuer is obviously engaging in these activities and they don't have authorization, yes, they are non-compliant issuers in this scenario. And in these cases, I can fully understand that trading platforms wouldn't be happy to list such stablecoin because the issuer is in breach, because it's engaging in these activities without authorization. But on the other side now, what if we have issuer, again, in the US, and the issuer doesn't offer the stablecoin to the EU? It doesn't seek its admission to trading either. Let's just say it doesn't care about the EU market at all. And we have a trading platform in the EU that thinks that this stablecoin is quite interesting. They would like to list it. Well, technically, the issuer is not in breach of MiCA because the issuer itself doesn't engage in these activities. It's just a trading platform that wants to trade it, right? So they technically should be allowed to admit them to trading at the trading platform own initiative because the issuer is not in breach, because issuer is not looking to engage in these activities. However, based on these guidelines, it's quite clear that if you are not authorized under MiCA, and it also means the issuers that wouldn't need that authorization, because not all of them would need them if they don't engage in the activities on the left. But unfortunately, based on the actual guidelines, EU trading platforms cannot list non-compliant stablecoins. The situation is slightly different when you offer crypto asset services, because technically you are still allowed to provide services in relation to stablecoins issued by non-compliant, so-called non-compliant issuers, because not all of them are non-compliant, they just don't need authorization. But you are allowed to offer crypto asset services unless the service that you provide can constitute an offer to the public. This is where obviously things get tricky because the actual definition of what means to offer to the public or to solicit the customers is very, very, very broad as of now in the EU. So we don't know what national competent authorities will do in this regard. It's quite interesting to see. I know some regulators think there is a room for crypto asset service providers to still provide the services because they don't view this as the offer to the public. Some regulators may be more stringent and just, I don't know, listing the token for the exchange can be viewed as offering it to the public because it's visible. So quite a tricky territory here as well, but technically they are in better position than trading platforms that are immediately banned from offering them and listing on their platform. Another interesting thing I wanted just to note is privacy coins. So there is a misconception that there is a ban on privacy coins. We don't have bans on the issuance because MiCA doesn't regulate the issuance. It doesn't ban the issuance of certain coins. There are only restrictions for certain actors that provide services in relation to them. So if you cannot make sure that you can identify transaction history and track the funds, then yes, if you are a crypto asset trading platform, you may not necessarily want to list them on your platform because you can't comply with the regulation if you can't trace the history back. But That's just a note for trading platforms, because again, it's not prohibiting the issuance. There are just restrictions for trading platforms, and it only is restricted to trading platforms. So it doesn't mean you can't offer them for the exchange, for example. And quite interesting part is the wording. So basically, this article targets crypto assets with inbuilt anonymization functions. It focuses on crypto assets themselves, as you can see, but some of these obfuscation functions, they can be actually inbuilt with the DLT infrastructure, blockchain, and validation methods themselves. It doesn't have to be inbuilt in crypto assets. So there is a room for interpretation here as well. That's what I'm trying to say. And let's maybe go to the last part before I will hand it over to Ian, because I think I'm nearing 1 hour 20. Okay,
We're good on
so
time, don't worry.
it's all right.
Take your time.
I'm trying my best.
You have plenty of time.
Cool. Right, so additional considerations, I think they're like last 10 slides. So we have market abuse rules now, which we didn't have in place before for crypto assets. So basically we have two sets of requirements. One of them will be obligations. So for example, having specific systems in place to prevent market abuse. And also we have prohibitions. So traditional prohibitions we have in traditional finance, like around insider dealing, market manipulation, and improper disclosure. We have it all under MiCA as well. Just a note for those of you that are not that familiar with MiCA, we do have these rules directly in MiCA. It's not market abuse regulation that is applicable to traditional finance. And just few considerations here that traditional derivatives will be covered still by market abuse regulation, not by MiCA. NFTs are technically excluded from market abuse rules, but I left asterisks just so I remember to tell you a bit more about it. So the problem is obviously about true NFTs, because technically if the NFT is truly unique, it's outside of the regulation. And that's why market abuse rules wouldn't apply, because NFTs are generally outside of the scope of MiCA. However, again, a lot of projects that we've seen on the market are not true NFTs. I could probably hold a completely different session about the crypto asset scope, but we don't have time for that today. But there are a lot of great articles also by Jonathan Galea. If you follow him, he broke down the topic very well about NFTs and them being truly unique or not. There are a lot of indicators you could consider, and I think 90% of projects legal teams review so far, they were not true NFTs. So if you are not a true NFTs, market abuse rules will apply to you. Another consideration is that market abuse rules have this extraterritorial scope, and the scope is basically very broad because it applies to both on-chain and off-chain environments. And I think the most important thing is that you have that expectation, right, to prevent market abuse. So you need to have systems, and these systems have to be compatible with MiCA requirements. So you need to make sure that the vendor that you choose for market abuse is able to provide system for both on-chain and off-chain environments, for example. And we obviously have solutions on the market like Solidus Labs. If you know Delphine Forma, she will be the best person for you to talk with. She will tell you all about market abuse solutions under MiCA. And just last note for market abuse is that we do have distinctions between market abuse regulation and market abuse provisions under MiCA. They are around prohibitions, they're around exemptions as well, like insider lists or buyback programs. So if you are interested in these distinctions, I'm also happy to share a table that I have somewhere around these specific distinctions. But just to keep in mind that if you are already complying with MAR, you may need to complete the impact assessment of MiCA, because this will be slightly different. And last thing that I forgot to add here, but there are also several considerations about MEMV. So I also highly recommend a few reads that I will paste in the chat later on. And then let's talk about some interactions, because we know that we have MiCA. MiCA is bespoke regulatory framework governing crypto ecosystem in the EU, but as I said many times by now, it doesn't operate in isolation. MiCA is not the only regulation or directive that you may have to consider. And one of the most prominent interactions would be with MiFID, with traditional financial regulation. And the interaction is quite important because MiCA will not apply to crypto assets that are already subject to other financial legislation, such as MiFID. And this category includes certain products that are obviously subject to MiFID, and they will not be subject to MiCA. So if your crypto asset meets the criteria of transferable securities, money market instruments, derivatives, UCITS, emission allowances, etc., then it will not be subject to MiCA, it will be subject to MiFID. And we do have guidelines, so if you're interested into understanding some nuances, etc., there is a report from ESMA, I think it was updated actually, with some of the nuances per each category, how you can distinguish. It's quite interesting about asset reference tokens and synthetic backing as well. So highly recommend the read. It can be very useful. And then we have also interaction with PSD, PSR, payments regulation in general. So a lot of industry members basically noted that we have this overlap, which is very tricky. And the whole problem is that we have this bone of contention in the industry where EMTs are classified as e-money. We have Article 48, where it's quite clear that e-money tokens are deemed to be e-money under EMD, which means they are funds under PSD. So in these cases, it means that certain services, certain activities can be considered as providing or facilitating payment services, which can require additional regulation, additional authorization. So on top of your MiCA authorization, you may also be facing additional requirements under Payment Services Directive or future regulation. So in interim, we did have letter sent to ESMA and EBA from European Commission about this specific interplay, and I also recommend the read. And they actually specify that we need to provide a complete impact assessment about services that may need this separate authorization and services that may be falling outside of the scope. However, we know that some of these clarifications may be coming with the updated payment regulations, which will obviously help us identify whether certain exemptions exist. However, we still don't have the regulation coming anytime soon. So there is a recommendation for no action letter to be issued, but also the recommendation to simplify the process for CASPs that will still need that additional authorization, because in some cases it will be still required, but they want to make sure the process is more simplified than it would be right now. And then DORA. I'm not DORA expert, just to clarify, but MiCA will work alongside DORA, which is basically all about operational resilience, ICT risk, etc. So it's actually quite interesting because also us as blockchain analytics, we work with different companies and they actually start to require DORA compliance also from their vendors like ourselves, because they need to make sure that all their third parties also have strong operational standards, right? Because technically, if something goes wrong, it's the regulated entity that is liable, not the vendor. So it's just quite important to note that DORA is no longer just about your own operational resilience. It's also about the operational resilience of your counterparties, because ultimately it will be your liability if something goes wrong. And then let's come back to AML, and it will be probably, hopefully, smooth transition to Ian's demo afterwards. But we also have, obviously, traditional AML compliance. Obviously, MiCA is a new framework. It's not AML regulation. It's all but not AML regulation. It's pretty much prudential conduct, authorization, consumer protection, white papers, disclosures, all these things. But we still have AML, and we still have TFR, and we shouldn't be forgetting about these parts of compliance, because these parts of compliance are actually bringing accountability to the crypto ecosystem, and that accountability is actually what drives trust, and trust ultimately drives adoption, which is a good thing. I'm not saying regulations are perfect, because also MiCA is far from perfect, but let's see how the rules play out in practice over next year or so. But we do have TFR, we do have AML, and TFR is obviously fairly new because we did have travel rule expectations for traditional providers in fiat transactions. Now we have the similar obligations to transmit the information about originator and beneficiary, right? So we need to collect the information, identify the information. You also need to conduct due diligence on counterparty VASP. And obviously there are some problems, because as of now, we have a lot of solutions on the market and they just don't speak to each other. There is a big interoperability problem or reachability problem, if that makes sense, because you may be leveraging solution, but if they can't speak to each other, then you can't transmit the data safely and obviously comply with TFR. Obviously, there are solutions that are more integrated than the others. We also are integrated with Nota Bene, which is our partner vendor. So if you still think about travel rule compliance, I would like to remind you that travel rule compliance is no longer optional. It's mandatory. And also we don't have that transitional period that we have for MiCA compliance, so for securing authorization. So just a note here, if you are not travel rule ready by now, you are technically in breach of regulation. And even though we didn't have any major enforcement action as of now, you don't want to be the first one to find out about the enforcement, right? So just to make a point, travel rule compliance is mandatory. Travel rule compliance in the EU is also going beyond the FATF expectations, because we have expectations regardless of the threshold. And also there are expectations in regards to self-hosted wallet transactions. So quite a lot to digest. And if you still don't know what to do, just talk to the team at Nota Bene. I'm pretty sure they will be more than happy to walk you through everything you need to do for travel rule compliance. And then AML. So obviously AML is a cornerstone of the compliance and bringing that integrity to the crypto ecosystem. And we've had AML compliance before. It's nothing new, right? It's been before. We had FATF recommendations. We had a lot of guidance around red flag indicators. So basically, all CASPs are still expected to comply. They still need to establish policies and procedures, whether it's for like customer identification, transaction monitoring, reporting suspicious transaction. They need to have measures in place to properly identify and verify their customers. They also need to leverage blockchain analytics, because let's be honest, we do have that transparency that we do not have in traditional finance. Obviously, there are still some problems, there are still some issues that we have to come up with solutions on a daily basis, but we do have the transparency that can be leveraged in the best way possible using blockchain analytics, because you can literally build your transaction monitoring policies, procedures using blockchain analytics. You can set up your risk engine, which is just an amazing thing that you can do. But obviously, you still need to do it within your business risk assessment, risk appetite. You need to remember that AML shouldn't be a tick box exercise. It should be adjusted to your own policies, procedures, risk appetite, local nuances, regulatory expectations. And this is also something we are happy to help here at Merkle Science, because we've built a lot of rules that could be incorporated into transaction monitoring. And these rules I'm talking about are EBA guidelines, because we did have EBA guidelines some time ago. And similar to what we received from FATF, which was the red flag indicators guide, we also have guidelines from EBA around criteria that may be risk increasing factors, criteria that may be risk decreasing factors, but also, the general distinction between behavioral flags and source of funds flags that we support here at Merkle. So I guess that on that note, I will finish and hand it over to Ian to show you how these roles can actually work and how they can be set up using Merkle Science platform. But yeah, thank you all, and I'll dive right into the questions. I will just have a sip of tea because I think I need it after 1 hour and a half, and I'll hand it over to Ian. Thank you.
Thank you very much, Natalia. I hope, everybody learned a lot. I definitely did. I can say with confidence, if it wasn't for this presentation and I had to take the assessment, I highly doubt I'll pass. So really appreciate Natalia taking the time. Now, as I mentioned at the start, before I go into the demo, we will be taking a short 10-minute break. So for those of you who need to use the washroom, get some coffee, please do. During this time as well, if you guys have any questions, please do post it inside the Q&A. All right, welcome back, everyone. Glad to see that we still have most of you. It's always tricky introducing a long break in a webinar because you never know if everybody's going to come back. But I'm glad to say, the bulk of you are still here. So I do feel honored. My section isn't as anywhere near as exciting as Natalia, but, I'm hopeful that it will be of value to you guys still. Now, having spent, more than 1.5 hours with us, I'm hoping everybody on the webinar is familiar with Merkle Science, but for those of you who aren't, in a one-liner, Merkle Science is a blockchain analytics company. We specialize in helping private and public sector organizations develop solutions to track and trace cryptocurrency transactions in order to build a safer Web3 industry. Right. With that said, we have multiple different tools in the market used by, exchanges and regulators all around the world. But for the focus of, today's webinar, what I will be doing is simply providing you guys with a short demonstration of our Compass solution, which is our flagship tool, which we have developed to help crypto businesses with their AML. Right. So Compass is developed as a wallet and transaction monitoring solution. And like Natalia alluded to, it's designed to help you guys develop risk policies to comply with the regulatory requirements in your respective jurisdictions. So without further ado, let's just jump straight into the demo, right? So what I'm sharing across right now is simply the landing page that what our clients would see when they log in. Being a wallet and transaction monitoring tool developed for enterprise compliance teams, it's very important that the tool, upon logging in, immediately lets you know, how many alerts have been generated, how many alerts are pending, as well as, how that is distributed across the different risk levels that we've been detected. Right, so what you guys are looking at right now is our tools dashboard. Again, it's what provides users with a bird's eye overview as to how well the platform has performed. Not only can you track the number of alerts, you can see, the distribution of the screens across all the different blockchains and currencies that we support, as well as, one of the greatest value, I think, of our platform is its customizability, right? One of the things that Compass does very well is that, we've recognized very early on that most of our clients are not just operating in one jurisdiction, but chances are, you guys want to expand globally. That's the whole point of crypto, right? It's a decentralized world that allows, businesses to serve the entire globe. Now, while that is probably, a dream come true for your sales team because that means that, they can sell to the entire world. For the compliance officers on the call, I think you guys would agree with me that it's a compliance nightmare, right? When you think about, the Web3 being this new industry, regulators around the world trying to develop their own framework, what it also means is that the approach that you take in one jurisdiction is likely not going to be the same in the other jurisdictions that you operate in. And so while your sales team is having a ball, selling to the entire world, US compliance officers have to develop appropriate risk policies that are commensurate to the different jurisdictions that you operate in, and you have to constantly update those risk rules to take into account new changes or evolution in the industry. So within our tool, users can create their own rule sets, and that's something that I'm going to show you guys. But on the dashboard, you can also keep track of, what are the rules that are flagging most often. And because we have a built-in case management solution as well, you can also kind of easily see, how the cases have been distributed, and you can even track, which one of your compliance officers are perhaps a little bit slow in handling these cases. Now, when it comes to using the platform, obviously most of our clients, they simply do an API integration because, you're vast and you're facilitating, tens of thousands to millions of transactions a day. You definitely don't want your compliance team, manually screening them, right? So we do have a robust API integration that most of our clients utilize, but for some of our smaller clients, we do provide them with the option of simply copy and pasting addresses or transaction hashes right at the top. And for some of our mid-size clients, we also have the option for them to simply upload CSV or Excel files with the addresses or transactions that they want to screen, right? So all of this, is very user-friendly. Now, the other thing that you guys probably want to take note when it's selecting a vendor as well is that you want to make sure that the vendor has sufficient coverage, right? Crypto and blockchain is very mature today. There are, hundreds of blockchains out there and tens of thousands of tokens. So you definitely want to use a provider that covers, all the blockchains that your team is looking at, and then obviously all the tokens that your business team is looking to support as well. Oftentimes, one of the challenges that we see, businesses face is, the sales team is always, in a rush to list as many tokens as possible because that's how they make money. But the compliance team sometimes, struggle because if you don't have the appropriate AML coverage, then you cannot sign off on listing that token. Right. So, here at Merkle, very proud to say that, we have one of the largest coverages. We support thousands of tokens across over 100 different blockchains, right? So all of that, you can also see within the tool. Now, a couple of other things that I want to just quickly run you guys through before we get into the risk policy and what an actual screening of an address looks like, is the fact that, again, recognizing that a lot of organizations are probably operating in many different jurisdictions. Within our tool, we also have this concept of what we call workspaces, right? Now, you can think of a workspace as a self-contained environment, right? Because oftentimes, again, if you're operating across the US, the UK, Asia, you might want, separate workspace setup for each environment so that, there's no data overlaps, you preserve your client's confidentiality, but more importantly, from a compliance perspective, you may want to designate different set of rules for each workspace that is, again, commensurate to the jurisdiction that workspace is designed for, right? Now, with each workspace, you do have the option to, again, configure the settings. And then under the product configurations, there's a couple of things that's pretty cool, I must say, when it comes to blockchain monitoring. Now, presumably most of you are familiar with the technology from a high level, but just for completeness, I will say that blockchain is this decentralized database, and what that means is that for most blockchains, as long as you have the user's cryptocurrency wallet address, anybody can actually go online and take a look at all the transactions that that address has done, and that is a game changer when it comes to monitoring. Because what that means is, for the first time as compliance officers, you're not stuck there waiting for your client to provide you with information about their transactions. But what it means is that once you've identified their wallet, you can independently go online, look up all their transactions, see what are the accounts that they're interacting with, and expand your investigation and scope to those counterparties as well. On top of that, one of the great things about blockchain is, again, because all the information about these transactions are online, one of the things that we're able to do is offer this service called continuous monitoring. And what continuous monitoring simply means is that if you are analyzing a wallet in Compass with continuous monitoring turned on, we will actually monitor that address's activity directly on the blockchain. So every time it does a new transaction, we'll automatically pick it up, rescreen it with that transaction in mind, and update the risk score automatically. So, you can do real-time monitoring of not just your clients' wallets, but even their counterparty wallets if you want. The other really cool feature that we have in Compass is something called smart contract monitoring. So, for those of you who, again, are a little bit more tech savvy in the space, you're probably familiar with, DeFi, stablecoin smart contracts. Today, a lot of transactions are facilitated with smart contracts. And, with Compass, you can easily upload smart contract addresses. And again, we will provide you with 24/7 monitoring of those smart contracts where we can notify you in the event there's any suspicious transactions that occur. Now, a lot of our clients in the space, over time, we've realized that they've also developed their own custom blacklist and whitelist. These could be, clients that you've approved based on pre-existing relationships, or you might have blacklists that are specific to your jurisdiction, right? So the other thing that I also want to point out is, again, in Encompass, we want to facilitate organizations of all type across all jurisdictions. So if you guys have your own custom list of addresses that you may want to blacklist, whitelist, or simply flag for whatever reason because they're a VIP client and you want to treat them differently, again, Compass allows you to do all of that seamlessly, right? You can easily create a blacklist, give it a description, addresses I don't want to transact with, assign it a risk level, and once the blacklist has been created, all you need to do is just copy the addresses you want inside it. And anytime you're screening these addresses or screening an address that's interacting with one of these addresses, we will automatically flag it for you, right? And finally, last thing to cover before we get into the most important part, which is the risk policy, is our case management. Now, we know a lot of enterprise organizations have their own built-in case management, and good news for you, we do integrate seamlessly with a lot of those. But for those of you who don't, rest assured, within Compass as well, we do have a built-in case management system where you can automatically create cases whenever alerts of a certain risk level have been triggered. You can designate how you want those cases to be assigned. And then, of course, from an approver perspective, you can also introduce a tiered approver workflow, right? So what that means is that, you can have all cases be assigned to a junior case officer and then require cases to be approved by a senior officer before they're closed, right? So again, Compass has been designed really, for crypto businesses of all sizes, although we do have a focus on enterprise. Now, with that said, that's some more boring stuff. Let's get to the, what most exciting features about Compass, which is our risk policies, right? So like I mentioned, very early on, we recognize that, again, our clients are operating in jurisdictions over the world, and we wanted to build a way to allow them to quickly create policies and then evolve these policies to meet changing regulatory obligations. Now, the way that you want to understand a policy in Compass is a policy is simply made up of a set of rules, right? And within the tool, you can easily, without any coding knowledge or development assistance, create your own policy by giving it a name, description, decide on whether it's an address or transaction policy, and then if it's an address policy, you also have the option of creating either a source of funds or a behavior-based policy. Now, what's the difference? Now, historically, when blockchain analytics was first introduced, most of the tools out there simply focused on what we call source of funds risk, right? And what that means is that if you're screening an address, what is the risk of this address based on where we know funds had come in from and where funds had gone out to, right? And given the transparent nature of the blockchain, what it means is that, you're not just able to see if wallet A had received funds from wallet B, you can actually go beyond wallet B to say, hey, wallet A received funds from wallet B, which received funds from wallet C, D, E, so on. And, maybe 5 hops down the road, it actually originated from a sanctioned exchange or a sanctioned wallet, right? Blockchain allows you that level of transparency and that level of direct and indirect analysis. Now, some of the problems with this approach is that, in order to detect if funds were coming from, let's say, a darknet marketplace, a sanctioned wallet, the premise is that blockchain analytic providers had to maintain a database of addresses belonging to these known actors. And kudos to a lot of the government organizations around the world, including the FATF, who regularly publish and update their sanction list, right? So all of that, becomes core data that, we analytic providers use in order to flag lists. Now, the problem with that approach is that it's a database approach, right? It's great that FATF is saying, okay, these are the cryptocurrency wallets linked to, these sanctioned entities. But if you think about it, what that also means is that you're basically telling these entities, hey, these are the addresses that we know are associated to you. And what does that mean? Well, these bad actors are simply going to create new wallets, right? And the ease in which, these bad actors can create new wallets is, it's crazy, right? They can simply create a smart contract and automate the creation of thousands of wallets at a click of a button. Now, recognizing that limitation of a pure database approach, Merkle Science was the first provider in the space that actually introduced behavior-based monitoring, right? And for those of you who are, traditional compliance officer, you might think, well, behavior-based monitoring, isn't that kind of expected if you're doing transaction monitoring? Well, you'd be surprised. For the first couple of years in the blockchain analytics space, nobody was looking at behavior, right? But we were the first one to actually introduce it in the market. Now, I'm going to show you guys an example of how you guys can create a couple of rules. But before I do that, I do want to flag up for those of you who are unfamiliar with, the type of rules that you should be looking to create. My colleague Natalia had cited this document, but I did want to flag it out again. In September 2020, the FATF had very kindly put out a document called Red Flag Indicators, where if you scroll through the document, they were also kind enough to give you some examples of the type of transactions that you should look out for, right? Things like, users making multiple high-value transactions in short succession, staggered and regular patterns in the way that they transact, things like, depositing funds in an exchange and withdrawing it immediately. All of these are very common behavior indicators that a traditional compliance officer might be familiar with. But then, of course, this is overlaid with, a bunch of different source of funds examples. Things like, if it's coming from a crypto ATM, if it's coming from a unlicensed FASP, right? One of the big risk of virtual exchange service providers, specifically exchanges, is that simply by the way that these exchanges hold, maintain, and facilitate client transactions, a lot of these exchanges unwittingly act as mixers, right? And a lot of criminals recognize this. So oftentimes they would simply launder their funds through an unlicensed exchange with weak KYC and AML procedures. So that is another risk factor for you guys to take into account, right? And it's also one of the reasons why regulators around the world were in such a rush to try and regulate crypto businesses as soon as possible in order to deter criminals from using them as mixers. Now, with that said, coming back to the tool, creating a policy is very simple. All you need to do is, give the policy a name. So let's call this, for example, MiCA. Give it a description, MiCA rules, choose whether we want it to be an address or transaction policy. In this case, let's take a look at a couple of source of funds examples first. And I click add policy. Once the policy has been created, we do have the ability for you to actually analyze how effective this policy has been, where it will tell you, how many addresses have flagged against it. In this case, none, because I have no rules yet. And that's what I'm going to do next, right? So under the rule list, if you wanted to create a new rule for this policy, again, no coding necessary. All you need to do is click add rule, give it a name. Let's call this, sanctions violation. Assign it a risk level of, let's say, critical. And then all you need to do is add condition and choose from our drop-down menu one of these conditions for this. right? So with a name like sanctions violation, obviously we're trying to design a rule to detect for sanction exposure, right? So, I can choose, for example, this rule where it says if an address has directly, and this by direct, I mean one hop exposure. If this address has directly, let's say, received, sent, or both, sent and received, so I'm going to choose both. If an address has directly either sent or received payments from actors of a certain type or subtype, right? In this case, I want to be very specific, so I've chosen the subtype category, and now simply choose, OFAC cluster, and let's say, entities from a sanctioned country, right? So I've selected all three. I can choose to set a minimum threshold if I want. In this case, I want the rule to be as sensitive as possible and alert me whenever there's even a dollar exposure. So I'm not going to set any minimum dollar value, nor am I going to set any minimum taint. And then voila, as easy as this, all I need to do is click Save Rule, and I now have a rule that will operate immediately that would flag any address that I'm screening as directly transacted with a known sanctioned wallet, right? Now, the rule engine is, very user-friendly and it's, again, very robust. By that, I mean, not only can you create rules with a single condition, you can actually create rules with multiple conditions, right? In this case, I'm going to choose the or condition, right? So I want to say, flag me critical risk if the address that I'm screening has either directly or, in this case, indirectly transacted with sanctions, right? Because it's not just important for me to be aware if the wallet has directly received funds from sanction, but as criminals today are getting more sophisticated, a lot of times they might layer their funds through a couple of intermediary wallets first. So I want to be alerted if an address has both direct or indirect exposure, right? And again, in this case, I can set a minimum dollar value if I want, and all I need to do is click Save Rule. Now, for categories like sanction, we definitely advise you guys to be as stringent as possible. But one of the reasons why we've decided to separate out direct and indirect is because for certain other categories like, say, gambling, you may want to flag direct gambling exposure at a higher risk level than indirect, right? As well as, depending on the thresholds that you designate, that again should be commensurate to your jurisdiction and business, and of course, risk appetite, you may want to adjust the risk level accordingly. So the tool allows you a high level of customization. Now I'm just going to go ahead and click Save Rule, tell me, threshold, Save Rule, and then voila, I now have a rule that's immediately operating. Now, being a compliance platform, it's also very important that not only do we allow you guys to create rules, but the risk policy comes with a built-in audit trail, right? So we do log every time rules are created, every time rules are modified. I mean, all of this can be generated as a report for your local regulators if necessary. So this was a quick example of a source of funds rule, and I also want to take this opportunity to maybe show you guys a quick example of what a behavior looks like. Again, creating a new policy, this time I'm going to select behavior. The interface is exactly the same, but the only difference is now when we go to rule list and I click add rule, the conditions that we see in this drop down have now changed, right? They're no longer focusing on where funds are coming and going. Instead, they're focusing on the behavior of the wallet itself, right? Now, common ones that you guys might be familiar with would be things like, dormant account reactivating. So things like, if an address has, let's say, transacted after being inactive for, let's say, 36 days, right? Dormant account reactivation. Other rules that you guys might be familiar with might be, a sharp increase in volume or frequency. So if an address has transacted, let's say in the last 5 days, at least 10 times what he normally does, right? So, do we have an abnormal spike in the amount that the wallet is transacting. Now, the great thing about behavior-based rules as well is that, again, we're not limited to creating rules with a single condition, but as your compliance team, observe new behaviors in the space, you can actually um, pick and mix these conditions in order to detect some more complicated typologies. Now, let me give you an example. One of the things that we see very often in the crypto space is scams, right? It's very common for, ransomware scams, love scams, to take place. Now, one of the things that we see very common is that in a lot of these scams, typically what the bad actor is asking the victim to do is to, send about $1,000 worth of BTC to a wallet of their choosing, and then the bad actor would then consolidate all of those funds into a new wallet. Now, recognizing that behavior, what we can do with the tool is, we can say, okay, if I know that oftentimes the bad actor would be receiving funds from many different victims, I can say, okay, if an address has received payments from, let's say, more than 100 counterparties, because, realistically, if you're an exchange and most of your users are retail users, it's very unlikely that the retail user would be receiving funds from so many different counterparties, right? Even if they are, playing around with many different DeFi platforms, still oftentimes, they may transact between the 10 to 50 addresses at most. So if you have an address that's receiving funds from more than 100 different counterparties, that's an immediate, potential red flag. Now you can combine that with another condition that says, okay, not only is it receiving funds from a lot of different counterparties, it's then sending funds into a newly created wallet, right? A wallet created in the last 24 hours. This is an example of them, consolidating funds into a new wallet in an effort to try and hide where the funds have come from. And finally, if you wanted to, again, be a little bit more specific, recognizing that a lot of these scams typically ask for $1,000 worth of BTC, you can see that this address is also receiving payments between, let's say, 900 to 1,000. And why do I give an extra $100 buffer up and down? Is because the crypto space is very volatile, and so oftentimes the amount that the user bought may have been 1,000, but by the time they've transacted it, the value may have fluctuated slightly, right? So in order to capture all these transactions, it's always better to kind of give a little bit of a buffer. And again, once this is done, we call this suspected scam consolidation. Consolidation wallet, assign it a risk level, in this case, high, because again, these are just behavior indicators, it's not conclusive. Once I'm done, all I need to do is click Save Rule, and again, I have a behavior-based rule that is applied immediately. So this is how risk policies work now. For any users coming on board, we do have a lot of template risk policies based on things like the FATF red flag indicators, many others. And so if necessary, we're more than happy to help you get started out the box with some of these templates. Now, with that said, I want to quickly then jump over to what the alert looks like within the platform, right? So it's great that you can, modify these rules, but obviously, what does that look like when something flags? So let's say, we wanted to screen an address. In this case, I'm using the manual screen function at the top, pasted an address in, press enter to run a search. Tool's telling me immediately, this address could be on more than one blockchain. In this case, I want to screen it specifically on Tron. So clicking on the Tron side, and immediately it goes in, right? So immediately the tool is telling me on the left, you can see that this address has a risk level of high, and what that means is that there's at least one rule that's flagged with a risk level of high. Right, in this case, I can see very quickly as well that there are actually 3 rules that have triggered, right? So there are 3 open alerts. It's on the Tron blockchain, and this wallet has not just transacted, Tron, TRX, but it's also transacted USDT and another token called BT tool, right? Now, over on the right, right at the top, we can see, the address summary. We can see how much of each token was transacted with this wallet, if there's any balance holding. And of course, we have the option to toggle to see this in other fiat values as well. Now, if I scroll down, I can then quickly see, what are the rules that have flagged. In this case, it's flagged, incoming from high-risk organizations, a couple of other rules. This is probably what's most important to me. If I scroll down a little bit more, the tool is also then showing me an exposure pie chart, right? So again, blockchain is great, full transparency. And so what we're seeing right now is both the deposit and the withdrawal exposure. And the way that you want to interpret this, and why there's a two-layer pie chart is because the inner pie chart represents the direct exposure, right? So this address has received, $163,000 directly from other exchanges, sent out, 94,000, sorry, received 94,000 directly from high-risk organizations, and received, 5,000 indirectly from exchanges, and 2,241 indirectly from high-risk organizations. Similarly, I can also see the withdrawal exposure. Now, all that's great, but typically you might want to know specifically what are these entities and their names. So if we scroll further down, we can also see very quickly, a table that lists down all the entities that this address had exposure to, the amounts, direct and indirect. And indirect is great, but as compliance officer, you probably want to ask yourself as well, how indirect is indirect? Because obviously your analysis of the risk changes if the exposure is, let's say, one hop out versus two hop versus three hop and versus four hop. So recognizing that, within Compass, we've also taken the liberty to integrate a free graph that automatically maps out the exposure to all the entities that we've directed, both direct and indirect. Right now, in this case, the wallet is not that complicated, so we can very easily see, all the direct deposits coming in from Binance, MEX Global, high-risk organization called Bitpin, Nobitex, as well as the funds going out. Right now, in situations where the graph is more complex, you may also want to apply filters where you might say, okay, you know what? I just want to focus on all the outgoing transactions to high-risk organizations, in which case you can selectively apply a filter, and the tool would automatically just flag those that meet the filtered requirements, right? And in a situation like that, where we can see funds directly going out and indirect, we also have the option of clicking on any one of these transaction links in order to pull up specific transaction hash, the amount, and the date and time those transactions took place. And this is especially important when you're analyzing indirect risk, because oftentimes what you're trying to answer is are these wallets that were created by the user just to kind of layer his funds, or did they really change hands? And looking at information such as the date and time, the type of wallets, all of this can be important data points that factor into your analysis, right? And for, our more advanced clients who want to do a deeper investigation, we also have an option for them to simply click a button and open up this graph in our investigation tool in order to do a deeper assessment. Now, of course, within the tool, you always have the option of reviewing the entire transaction history of an address. So if you do specifically, want to get down into the details, you can, right? Again, options for you to filter and export this information in case you want to do your own analysis on top of it. Being a compliance platform, again, it's very important that we're maintaining, comprehensive audit logs where we do log every time an address is screened, whenever the risk level is updated, and any action taken in relation. And, once your assessment is done, the last step, of course, is to file a report. And, again, we want to make your life as easy as possible. So within the tool, we have built in an option where you can immediately export a copy of the report, where you can select what is the information you want included. Okay. So that's basically Compass in a nutshell. Now, obviously, there are tons of other bells and whistles, and I would love to spend another, hour walking you guys through everything. But in interest of time, I'm just going to pause here. What I will say though is that, if any of you are interested in, playing around with the platform, testing it out, or just having fun with it, we're always open to offering, trial licenses for users. So feel free to write in, to myself, any one of our colleagues here in Merkle, and we'd be more than happy to facilitate setting you guys up with an account so that you can try it out yourself. Now, with that said, I want to thank everybody for staying with me, right? Hopefully, that was interesting for you. And with that, I will like to invite my colleague Natalia back to the stage where she will be going through some of the questions that have come in. Once again, I thank everybody for posting questions. I see we actually have quite a lot, 32 questions is at the Q&A. I'm gonna speak on Natalia's behalf to say, there's no way we're gonna be covering all of them. I think probably five, maybe 10 at max. So we'll see. But like I said, for those of you who we don't manage to get your question, feel free to write in and we're happy to continue the discussion offline. Right. But with that, back to you, Natalia.
Thank you, Ian. Let me go through some of the questions because I will try to pick something that is the most beneficial for the wider audience. If you have any more specific question related to your specific business model, I'm happy to take this separately as it will be more specific to you. As far as we know, there is no official statement from the ESMA on its position on USDT at the moment. Could you comment on this point? So yes, we don't have any official statement on the USDT specifically, but what I was talking about before was the position on non-compliant stablecoins. So obviously Tether is not an authorized issuer here in the EU, which means that technically trading platforms will be prohibited from trading it, listing it on the platform. And I will actually paste in the chat because I think that will be easier. I can read it out loud, but obviously feel free to use the link. But the ESMA statement basically says that CASPs operating and trading platform for crypto assets are expected to stop making all crypto assets that would qualify as ARTs and EMTs, which is Tether, but for which the issuer is not authorized in the EU. Different rules obviously apply to other crypto asset services, or like, for example, the exchange, because this has to be in combination with the actual offer to the public, which is a different scenario. But I will just try and paste it here in the chat. Let me just find that question again, or I'll just paste it in the actual chat. Just give me a second. Just trying to find where it was. Too many questions. I'm just sending the link. Another question that we have, when does MAR apply and when do market manipulation rules under MiCA apply? So this is quite straightforward, not in all instances, obviously, but if you think about crypto assets that are within the scope of MiCA, this market abuse provisions under MiCA will apply to these assets that will be within the scope of MiCA. So if you have any other crypto asset that will meet financial instrument criteria, that will be probably MAR. If it will be derivative of crypto as an underlying, it will be probably MAR as well. Obviously, there are some nuances like we discussed with NFTs. They're technically outside of MiCA, but not in every scenario. They are actually true NFTs. So there are a lot of considerations, but in general, to make it simple, if the crypto asset is within MiCA scope, MiCA rules on market abuse will apply, not MAR. Does AML apply next to MiCA? Well, so basically all AML compliance, whether it's AMLD or the extension like AMLD, AMLD6 or AML regulation, AML framework applies. It coexists with MiCA, right? MiCA is not AML specific regulation, but as I mentioned before, MiCA interacts with AML. So these provisions are still in place. They were in place before and they will continue to be in place with MiCA as well. Given that most travel rule solutions do not interoperate, how is the regulator approaching this, and how should CAS balance meeting the regulatory requirements without harming consumers by delaying transfers? That's a quite good question because we do have these technical issues with travel rule solutions. Obviously, the biggest issue is probably with the closed network. So we should be basically working towards standardized messaging, but also tools that can seamlessly integrate with other tools, because I know that these interactions, these bridges and layers are possible. I'm not saying it's still like, 100%, but there are solutions out there that can integrate. I think Safe Connect or Safe Gateway is the one offered by Nota Bene. But in general, I don't think that, regulator has any specific opinion on that as of now. It's more about the industry coming together to work on this and provide solution. And I understand that, travel rule compliance may be causing friction for customers, especially if we don't have full information, we have missing information, or regulatory requirements differ across different jurisdictions and the scope of information transferred. But I think that we should still prioritize risk-based approach, because what I've seen myself is that with travel rule, we often go into de-risking policies. So if we are missing information, or the VASP is foreign VASP but has different requirements, or it's self-hosted wallet transaction, we tend to block it entirely because we don't know what the regulatory expectations would be. So I think we just need to come back to basic a bit here and come back to risk-based approach, because we still have blockchain analytics. And even though we may not be able to collect information in all cases, which we should document, we can still understand the risk associated with this specific transfer, which is obviously something we wouldn't have in traditional finance. So I would say more emphasis on risk-based approach in cases where there are technical limitations. Geo-blocking cannot be an answer to reverse solicitation. Customers move and travel. Geo-blocking is incredibly harmful. And in your view, MiCA prohibits reverse solicitation. So no, MiCA doesn't prohibit reverse solicitation. MiCA itself, as a legal text, provides for this specific exemption. It's more about the soft law that is reshaping the intent of the regulation, because it's the guidelines that we receive that seem to be contradictory to what was the intent of the regulation. So technically we do have that exemption, but with the guidelines that we have, we can see that the scope of this exemption is so narrow that we don't know what are the actual situations where regulators wouldn't consider it an offer or solicitation. So that's a tricky territory, because we do have reverse solicitation, but it's becoming practically unworkable based on the guidelines. So I guess we'll let these rules play out and see what is the response of national competent authorities, because ultimately they will be the ones reviewing these specific scenarios. But I agree that it's just a tricky situation right now, because yeah, it's just not what the actual intent of MiCA was behind reverse solicitation. And in relation, will MiCA lead to crypto providers being established outside the EU with service offerings within the EU increasingly relying on reverse solicitation? Well, I don't think so, because again, you can't really rely comfortably on reverse solicitation if you still want to have the EU market share. And in many cases, most of the global companies want to have EU market share. They will still have to establish services here in the EU if they want to target EU clientele actively. And again, reverse solicitation, as mentioned before, is very difficult to prove, and it's also with a lot of caveats that we currently have. So it's quite tricky to rely on it, and it's quite risky. And maybe last two, with the EU frameworks based upon last year's politics and a shift away from the overreach demonstrated by the SEC, in the near future, will EU institutions be pulled back from overreach too, in your opinion? So my current view is that, MiCA was supposed to be crypto-specific regulation, but what we actually have is the replica of the banking and MiFID regulations. This is what it is. There are just few modifications that were added to call it crypto-specific regulation. It's not. The reason is that I think that in the EU, we tend to view the risks that we want to regulate even excessively. And for example, across the ocean, I think that the US is also seeing the risk, but they also see opportunities to capitalize on, because they want to include crypto assets within economic growth plan. And I think that over a few years, we will just consolidate and perhaps we will learn from each other. I would like to think that we will let MiCA rules to play out because it's a new regulation. We can see the outcomes and negative consequences now because it's coming into practice. But I think we need to let it, play out in practice for next year and see what we can do before we actually create new, like MiCA too, because it's still a new regulation. We need to see how it works in practice. But ultimately, I would like to think that something in the approach would change and we will learn from different jurisdictions because we risk falling behind in terms of being attractive place to set up activities. But that's just my personal opinion. And maybe just the last one for me, Car, because I think there are some questions for you as well, Ian. Does MiCA require licensing of crypto to crypto exchange if the exchange platform is non-custodial and peer-to-peer with order books? So obviously it really depends on the structure of the business. You would need a proper product analysis from technical perspective, how the service is actually being offered. But let's remember that under MiCA, just the mere fact of having crypto to crypto exchange is already regulated activity. Custody is just additional element, right? It's additional specific activity. So technically, if it's not fully decentralized service either, crypto to crypto exchange would be falling within the scope, even if it's not entirely custodial, because custody is a separate activity. But again, I would need to know what exactly is the business model looking like, because yeah, I can't really answer without having more details. I think there are a lot of questions, so please just feel free to reach out via my email or LinkedIn if you have, questions very specific to your business activities. I'm happy to answer, but again, just remember that I need a lot of information to actually properly reply to some of the questions because it's not a legal advice, just to be clear. But yeah, I will let Ian jump in because I think there are some questions for you as well.
Thank you, Natalia. I have no idea how you keep so much information in your head. But you impress me every time, when we run these webinars. Now, there were a couple of questions that had come in, so I'll take them under at least the product related one, very quickly. Does Compass break down a single transaction volume into sub-volumes of illicit categories? Yes, we do. Um, I do apologize. I know some of you have mentioned that my mic was a little bit soft. Didn't pick that up. But we will be circulating a recording afterwards to everybody who signed up. So hopefully, when you're reviewing the recording, you can turn the time up. With that said, I think the only other product related question is, can you set a date for when the policy can be effective from? Oh, that's a great question. Currently not, but you do bring up a good point. Oftentimes, these regulators they do let us know in advance, what are the changes that are coming in. So it does actually make a lot of sense to allow people to create a policy in advance and actually set a go live date. So, as a product lead, I will take that under consideration. That's actually a great suggestion. If anybody else has great product suggestions, do feel free to write with me directly. I'm always, appreciative of getting suggestions from practitioners like yourself. And then of course I've seen a lot of people also ask, when is the assessment? So happy to say that the assessment begins now, right? And now the way that the assessment is conducted, it is self-facilitated. So in a second I'm going to be pasting the link to the assessment inside the chat. Once I've done so, all you need to do is click on the link where you will be directed to our Institute platform. For those of you who are a returnee, you can simply log in with your previous credential. For those of you who are doing this for the first time, you will be prompted to create an account. But once the account has been created, you will be able to reuse that for subsequent certifications. Right. And again, gentle reminder for those of you who pass, feel free to share your certificate on social media. That'd be greatly appreciated by us and our marketing team. And it will, reflect all the effort that Natalia has put in developing these slides and coming up with this certification for you guys. So with that said, the link for the assessment is going to go live in 3, 2, 1. Right? It's now inside the chat. So for those of you who are still here, feel free to go ahead and get started. We will be keeping this webinar open for a couple more minutes in case anybody encounters any issues. If you do, feel free to just, post it inside the Q&A. And, one of our um, tech leads will jump on to address it. I did see another question come in. Does Compass identify DCMs, crypto ATMs? Yes, we actually do have a specific subtype category for crypto ATMs. All right, so because I will be shutting down the webinar in a couple of minutes, and I don't want to interrupt you guys if you're in the middle of the assessment, I will say this in advance. Thank you everyone for attending our webinar. It's because of your participation that these webinar series are a success. Like I mentioned at the start, we do regularly host more webinars on different topics. So we look forward to seeing you guys back again. And of course, if there are specific regulatory issues that you guys would like to see us talk about, feel free to write into the team to make suggestions, and we're more than happy to take your input into consideration as well. But on behalf of myself, Natalia and the rest of my team, thank you everybody for attending today, and we hope to see you soon.
Thank you so much, guys.